As most of you know, the California Civil Rights Department, formerly known as the California Department of Fair Employment and Housing, is engaged in a lawsuit in California state courts under the Fair Employment and Housing Act of suing Cisco Systems for discrimination against John Doe Adalet. CRT, California, or the Civil Rights Division, CRT is asserting that John Doe was a victim of caste discrimination, which is a form of discrimination covered by one of the protected traits in California's discrimination law, which include race, religion, ancestry, national origin or ethnicity, and color. In response to this litigation, in September of 2022, the Hindu American Foundation, HAF, filed a complaint with the District Court of the Eastern District of California, asserting 1983 claims of violation of its religious rights, and argues that claims of discrimination against John Doe violate their religious rights. HAF asserts that such work by CRD is a violation of its free exercise rights, its procedural due process rights, and its equal protection rights. And I've been asked to address the complaints or arguments raised by HAF in their complaint. Now, first off, what HAF notes in its complaint, so this is what HAF says, is that the core of Hinduism lies in its assertion that the divine is equally present in all, and that this divinity is the ultimate eternal omnipresent reality and reflected through immortal individual selves or pure consciousness, which takes form through a cycle of birth and rebirth or reincarnation. Moreover, as a result of this shared divinity, Hinduism asserts a moral obligation to ensure that one's thoughts, words, and actions uphold values like truth, non-injury, compassion, equanimity, generosity, and equal regard in order to honor the divine in all. HAF goes on to assert that CRD is actively pursuing religious discrimination enforcement actions against Hindu Americans in California state courts based on an inaccurate colonial assertion that Hindu beliefs and practices include a discriminatory caste system. HAF notes that the caste system was actually a product of the creation of British colonial control as opposed to based upon the beliefs of Hindu people. The CRD is actively pursuing religious discrimination enforcement actions based upon this inaccurate view of caste, which the British colonial government latched onto in a way to manifest its control over India. So in this regard, HAF makes three arguments. The first is that the action by Cisco violates its free exercise rights. And in this, HAF argues that a violation of religious rights exists when you impose special disabilities on the basis of religious status. As HAF argues, by CRD asserting the discrimination claims against Cisco, CRD is acting under the color of law to wrongly define Hindu beliefs, teachings, and practices to include the abhorrent practice of caste discrimination. By seeking to define these religious beliefs, CRD is imposing a special disability on the basis of religion by wrongly claiming that Hindus believe in and participate in a discriminatory caste system. Now, the problem with this argument is that factually it's an error. CRD is not seeking to define Hindu religious beliefs, but to prevent caste discrimination. And this is a form of discrimination that is practiced by a variety of religions, including Christianity, Islam, Buddhism, and Sikhism. Thus, CRD is not, nor does it need to define Hindu religious beliefs in order to attack caste discrimination. Now, half also makes a second claim, the equal protection claim. Half asserts that government may not use religion as a basis of classification for the imposition of duties, penalties, privileges, or benefits. Religion is a suspect class, as is national origin. As half goes on, by wrongly claiming that Hinduism includes a belief in the caste system, by adopting an enforcement position that caste discrimination violates California's Discrimination Act, and by filing enforcement actions that seek to enshrine its wrong and defamatory view of Hindu beliefs into state law, CRD is acting under the color of state law against Hindu Americans. This claim too suffers from an incorrect factual assertion that CRD is asserting that caste is a function of Hinduism. Half does not assert that caste discrimination is a part of Hinduism, but US law is very clear that governments have a compelling interest in the eradication of racial and ethnic discrimination that would in fact override religious beliefs directed towards such discrimination. And then the third claim that half makes is a due process claim. Half asserts that a law qualifies as unconstitutionally vague, not because it is difficult to prove, but whereas it is unclear as to what the fact must be proved. Seeking to define Hinduism to include the belief and practice in caste and the caste system is so standardless that it would actually require the very discrimination that it seeks to prevent. As half puts the argument, if CRD is correct, the caste discrimination is practiced as part of religious practice, the fact that caste is not a recognized form of discrimination would require religious accommodation of those who believe in caste discrimination. But this also misstates CRD's position. CRD is not arguing that CRD is arguing that caste discrimination falls under one of the protected traits. So it's either a form of race discrimination, a form of national origin discrimination, a form of color discrimination, a form of religious discrimination, or a form of ancestry discrimination. As such, given CRD's position, anyone who practiced caste discrimination in employment would violate its discrimination rules. In addition, CRD's claim is that Cisco Systems, Inc. engaged in intentional discriminatory conduct towards John Doe the Dalit. Thus, what CRD must prove isn't vague at all. It is that the discriminators engaged in negative employment actions against John Doe, motivated by his belief in caste. I want to finish up with a fourth claim, and this is not a claim that half makes, but this is a claim that I think would be much stronger than the other three that they have made, and which it would not surprise me if they don't eventually amend their complaint and make this claim. And that would be that by adding the concept of caste to discrimination provisions is a violation of the Establishment Clause, because the only religion that practices caste would be Hinduism. And by targeting caste discrimination, such discrimination laws would be treating the religion of Hinduism worse than any other religion. And government must be neutral with respect to all religions. I think this would be the strongest argument that they could make, but even this argument would not survive the way the Supreme Court has interpreted Establishment Clause challenges. Now, this is actually a form of interpretation that's sort of in the process of change. Under the older interpretation, in order to make an Establishment Clause change or argument, you would have to prove that the governmental action was either motivated by discriminatory intent against the religion, which this is not because it's motivated by a desire to eliminate the discrimination based on caste, that it would have an effect of, of, of discrimination against a particular religion. And this may be where their argument is strongest, in the notion of saying, hey, look, the effect of this would only be to attack Hindus. And then third, that there would be governmental entanglement with religion, which clearly would not happen here. But the Supreme Court has made it clear that when you're talking about a neutral law of general application, and that's what a law that prohibits discrimination does. It's a general application that applies across all fields. Those kinds of laws are deemed to be valid under the Establishment Clause. But that was the older form of interpretation. And the Supreme Court, just this past June, seems to be moving to a different form of interpretation of the Establishment Clause, saying that it would only strike down governmental actions that violate the Establishment Clause if those actions were not based on historical practices and understanding. This is where caste discrimination takes on a unique feature here in the US, because arguments that race discrimination in the US was a form of caste discrimination actually goes all the way back to the 1830s. Importantly, the very first anti-discrimination measure that Congress passed, the Civil Rights Act of 1866, that is the Civil Rights Act of 1866, it was very clear that Congress and the American public understood that act as attempting to prevent the creation of the Indian caste system in the US. This was a specific argument made by a number of the framers of the Civil Rights Act of 1866, as well as the 14th Amendment, which is where the constitutional challenges that Half is making comes from. So if you look at historical practices and understanding, the very definition of American anti-discrimination law was constructed around a desire to prevent the functioning of the Indian caste system. And with that, I will conclude.